So I've already started the recording, and I'm very happy to pass the floor to our kind speakers. So Professor Fischer, the floor is yours.
Thank you so much for that kind introduction. And it's always a pleasure to participate in these joint collaborations between the Catholic University of America and the Jagiellonian University. We have, as was mentioned, we have decades of collaboration in research, teaching, awarding LLMs and certificates, summer programs, and more creative things all the time, like these lecture series. So it's wonderful, to be a part of this and to have so many of you here today with an interest in the sort of linguistic aspects of legal collaborations. So I was asked to talk a little bit about my own personal experience in translation and my background. But I preface this by saying that I'm certainly not a trained translator. For that, the other speakers will be much better. I'm simply someone who has come across various, translation issues in the course of my career. And my interest in the challenges of legal translation really began because of my childhood. I was moving back and forth between the United States and the United Kingdom and spent roughly half of my childhood in both places and received education in both places as well. I'm legally trained in both jurisdictions. So when I became a barrister, which I did first in the United Kingdom, although I wasn't yet qualified as a lawyer in the United States, I was acutely aware of linguistic and cultural differences between the United Kingdom and the United States, and particularly as applied to law. Of course, using the wrong wording could get you into hot water with judges. For example, the punctuation mark that is known as the slash in the United States is never called that in England. It's called a stroke. And I was reading a date in court and I accidentally referred to the stroke as a slash. And even though it was completely obvious that I wasn't intending the English meaning of the word slash, which has another vulgar meaning, the judge paused the proceedings to correct me, and I felt absolutely humiliated. And that was just something that automatically popped into my mind. Oh, when I'm reading a date, this is the word that I first thought of, because I'm sort of traveling back and forth between British English and American English all the time. And of course, the date even itself is a kind of translation issue because, dates are presented in the Polish way, in the British system, in the order of the month and day, and in, the reverse for the American system. So there are lots of these differences that occur all the time. And, then if you add on lots of other national jurisdictions of English and dialects of English, it becomes highly complex. Canadian, which is kind of halfway in between British English and American English, New Zealand, Australian, South Africa, many African jurisdictions, India, and you see the complexity of which dialect are you choosing to use, even in the legal translation. Writing style also is very, very different in England and in the United States. For example, passive voice is frowned upon by many writers in the United States, but far less so in the United Kingdom. And prepositions can be used differently. They can be omitted in American English. For example, if you were saying something like a civil rights activist protests discrimination, in British English, you would say that civil rights activist protests against discrimination. Often more or often, as you would say in British English, more archaic sounding terms are used in British English, like the term whilst in British English. In American English, whilst is never used. Punctuation marks can be different, whereas to the positioning of the period and the comma with relation to quotation marks. The period and comma in British English is placed outside of quotation marks unless the punctuation mark is part of the quotation. In American English, the period and comma is always placed inside quotation marks. So again, you can look to a particular audience if your punctuation is not in accordance with the norms of that country. It can look as if it's a mistake or as if you don't know what you're doing. So again, decisions have to be made as to what audience of English you're translating for. These are serial commas are used in American English often, but not always, but not British English usually. These are just a few of many differences. So as I transitioned from being a practicing barrister in England and writing in the English style for an English audience, presenting cases for primarily English clients, but not always English clients. And often those cases involved language because the chambers where I worked was a defamation specialty chambers. And so, of course, the meaning of words is absolutely key in a defamation case. And we also, although this has changed, at that time, there were juries in most defamation trials in the UK. There's fewer juries than in the US. And so you also had to think about the effect of your presentation on ordinary people rather than judges. So when I came to the US after practicing for a little while in New York, where I had all kinds of issues of sort of cross-cultural misunderstandings and confusions with the practice of law, which seemed as if it would be very similar, but in many ways was extremely different. And the legal writing was also extremely different. American legal documents are much more polished than English documents, much more voluminous than English documents, and tend to repeat endlessly the same series of facts, which in England you might just do once. So I then became a teacher, a law teacher, and I moved beyond my interest in translation between different national dialects of English to considering legal translation from other languages and in between civil law and common law systems. And this happened because of my English training. It was assumed that I could teach comparative law and international law issues. And of course, to do that, you can't just compare legal traditions that are common law legal traditions, but you need to incorporate other legal systems, civil law systems, hybrid systems of the world into your teaching somehow. And I also benefited by the collaboration between my institution and the Jagiellonian University, as well as Luke Bartosik's programs in Poznan, and so became very interested, with teaching Polish students, largely teaching them courses that introduce them to the common law, thinking about how do you present the common law to civil law students in a language that is not their native language. And I also did some teaching and research in other civil law countries, notably Italy, where we have a program. I'm actually, my background, somebody asked about it earlier, I heard, and it's the Supreme Court in Rome, because we have a summer program there, which is admittedly free. It's the reverse. It's teaching common law students about a civil law system, the Italian system. And so you have to think about how to present civil law in your native language to other people with their native language. And also Iceland, where I've done quite a bit of work on constitutional reform. And, there are issues about the Constitution being, sort of having an English version and an Icelandic version, as well as how much are you taking from other systems that are common law in origin when it comes to issues of human rights. That constitution was crowdsourced. That was just why I became very interested in it, or at least the current reform project is crowdsourced with a lot of input from ordinary people, which also sort of raises issues of language. It has not been implemented. It sort of hasn't gotten that far, but it raising a lot of interesting issues in the world about sort of the input of ordinary citizens into their constitutions that we just saw, for example, in Chile with the recent constitutional referendum that failed. But I think there's still a very large movement in Chile for constitutional reform, and that involves legal translation, looking at other systems, other constitutions, and particularly some of the most influential modern constitutions like Canada and South Africa being common law systems that these civil law systems are looking at. And then also I've done quite a bit of work in Israel. I was a Schusterman Fellow there, and I teach in my comparative law course at the moment, based on materials. I do a comparison of a paradigm civil law system being France, a common law system paradigm being the United States, and a hybrid system, Israel, which grew out of, Ottoman Empire civil law with a huge dose of British common law, and then a sprinkling of religious law, as well as, sort of attempting to create their own Israeli law. And again, translation issues are there because of the three languages that are used in Israel, even at the moment, only one, Hebrew, is the official language because of political changes in Israel. But English is often used as a language that can be used between the, Palestinian community and the Israeli community, but it also has vestiges of colonialism attached to it. So, and you've got issues that in many things are not translated into English in Israel. So it can be difficult to do legal research there if you aren't a Hebrew speaker. And, so I've kind of had these different approaches to legal translation, depending on, who is the audience. So that is one interesting thing that I've kind of thought about is, how are you presenting these concepts to audiences from your own sort of jurisdiction or others, and across these big gulf of civil law, common law. But also as English becomes sort of the lingua franca, as it is, of the world legal system, where so many, of lawyers are using English as a kind of common language that, it's assumed lawyers from different linguistic traditions understand. Increasingly, you have people drafting contracts, for example, or writing articles in English when it's not, your native language. And, or even as we see, today, doing presentations in English to an audience, which, just looking briefly at the names here, this audience is probably more heavily Polish native language than English, yet we're presenting this in English. And that occurred, and I noticed that also when I was asked to do a speech at a high school Model UN competition a couple of years ago. And to my great surprise, the Model UN tradition in a Polish high school setting was completely done in English. It was incredibly well done. All the questions of parliamentary procedure, everything else were discussed in English, and all of the debate was taking place in English, and these were very, very young, students. So as that happens, we have issues about how do you draft a contract, for example, in a language that is not your own? And are you drafting that contract in English because it's governed by either English or British or American law, most likely, or maybe some other English speaking jurisdiction? So for a few years, I've been doing a course on drafting contracts in English for the Center for American Studies out of Poznan. And again, mostly Polish or Ukrainian students, but not always. We've done a few courses for that program where we've had people from all over the world, not the drafting course, but a different course. There was one that had 300 students from literally all over the world, almost every country in the world, which was an amazing experience over Zoom. And, that has, but the drafting in particular has raised a lot of issues about translation and how do you make sure that you're saying what you want to say and making it precise in a language that's not your own. So that's kind of how I became interested in legal translation. And then I had this experience that was mentioned with, collaborating on the Polish Civil Code. I would clarify that I wasn't the official translator and I wasn't in charge of that project. I was asked to participate as a native language consultant on the project. Because the translators weren't native speakers of English. And, one of the things that was sort of paramount in that effort to translate was to devote attention to the difficult issue of presenting Polish civil law institutions in English, trying to make those institutions understandable to those who are familiar only with the common law legal system in English speaking jurisdictions, but also sort of being aware that it's multiple jurisdictions. So, kinds of translation issues that you run across are, the many false friends between Polish and English, as well as the true friends, words like eventualnia seems like it would just be translated as eventually in English, but it's really much more like possibly, as I understand it. Sentence structure, how much should you follow the Polish sentence structure literally so that it sounds awkward in English, but is more true to the original? Often the sentences are just much longer with more dependent clauses in the Polish, and doing that sounds very awkward and not sort of crisp and precise if you render it directly into English. And how much do you need to stay faithful to the format of the original, and to the tone of the original, as well as the meaning? How, and in law, I think you can take less creative liberty because legal language must be more formal and precise than if you're translating, for example, a novel. But then again, it may end up sounding extremely awkward to the native English reader. And then, of course, there's the issue that there may not be any direct equivalent to an institution or concept or legal terminology in English. So often, through one approach, you're trying to get a functional equivalent. What is the term for the institution or the concept that has the same function as the source legal system does? And for legal terms, it can be very difficult and sometimes impossible to find a functional equivalent. So should you use the original untranslated term, or just try to explain it somehow? And so an example, I guess, that springs to mind is the sort of in Article 5 of the Polish Civil Code, the zasady współżycia społecznego, the principles of social coexistence, maybe, or cohabitation, these ideas somehow of these general rules of behavior of members of society that are acceptable at a given time or at a given place. And there's really no equivalent to that. There's no definition of those terms because the meaning is to be intuitively grasped. But the idea of this really comes out of former socialist systems. So there's no exact equivalent. If you call them kind of ethical rules, it's hyponymic with respect to the Polish because it doesn't encompass the whole scope of the meaning. And then you've got the question of where do you look for definitions of these terms? The Civil Code often has definitions of its own terms, but where do you get the English ones? In a common law system, English dictionaries, legal dictionaries, for example. And then finally, I guess, because I think I'm taking up a bit too much time, is the issue of how much someone can rely on machine translation. And I just recently ran across something very interesting where a district court in Poznan, Stare Miasto, the old town, found a translation of a book from Polish into English that had been done by a student who was not a native English speaker and used Google Translate for 92% of this. That was deemed to be defective to such a degree that it couldn't be deemed fit for professional use. It was contrary to what the translator had promised. And so there was a non-performance of the translation agreement, which is sort of interesting. At what point does a translation become completely defective? And, how good are these machine translations? Because everybody sort of does tend to rely on them. And so to me, summing up, legal translation is really about, there's no absolute science to legal translation. It's more of an art. And it really is sort of about developing as best you can without being native to a legal system or to the institutions of that legal system, an effort to really understand both legal systems beyond just linguistic fluency. And of course, this is interestingly true when you're translating between, or for multiple English-speaking audiences too. So it's not just an issue of translating into a non-English language, but even within English itself. So I sort of wanted to emphasize that as being this kind of transatlantic person. I think I'll stop there and, look forward to hearing what the other speakers have to say about this really important subject.
Thank you very much, Professor Fischer, for your extraordinary stories that you tell for all kinds of aspects of translation. So now I would be happy to pass the floor to Mr. Wojciech Jarosiński.
Good afternoon. Hello to everybody. My name is Wojciech Jarosiński. I'm an advocate. I work mainly with new technologies, with IT. But my history with translation between Polish and English dates back to 2011, to the year when I was taking a part in the LLM program, jointly run by Catholic University of America and Jagiellonian University. A part of that program is the ALP program, American Law Program, which takes place during the fall, winter, and part of spring months in Krakow. And I wanted to share with you few stories about what we did during the evenings in Krakow during the bleak weather that covers Krakow during the winter. One of those stories relates to a failure, actually. We were trying to properly translate court opinions from the Supreme Court of the United States into Polish to make a set of really interesting legal opinions and to show how American judges write their opinions. We didn't manage to do it well, certainly not well enough. So I won't be able to share the outcome with you. However, we invested the time we had in the evenings also in another project. And that project was related to guide to Polish legal citation. And in the chat, I'm sending you right now the link to a publication of a paper, Transformacje prawa prywatnego, which is like transformation of private law. And at the bottom of the list of articles, you will see a long list of authors, my friends from the ALP program, and the link to the guide to Polish legal citation. That guide is a compass how to cite legal acts, judicial acts, different decisions, how to name courts, Polish acts, and Polish official reporters, constitution, codes, statutes, and regulations in English. We gave it a thought, and if you were ever wondering how to, for instance, quote a part of opinion of a Polish court ruling, here you have a direct link to a guide which English words could be applied for such translation. Having completed the LLM program, I moved to the IT to practice law, and from that practice, during that practice, I had a lot of exposure to English language and English contracts, English proceedings, and I wanted to try to ask this question: whether translation is a tool at all for approaching the intersection of English and Polish language in the area of law. And to start with, I think it's necessary to ask this very basic and kind of philosophical question: what is the purpose of legal service? And obviously, the purpose of the services, legal services that we provide as lawyers, is to help individuals in their trouble. But then how do we help those individuals who are in trouble? We try to convince a court, the other party, a recipient, we try to convince them to our arguments on behalf of our clients. And how this convincing process happens? It happens through the application of words. But then the other question is, are these really words that help in convincing the other party or the court to our arguments? Sometimes application, proper use of good vocabulary is helpful, but at the end of the day, that's not the words that we are communicating, but legal concepts that are behind those words. That's at least what my experience tells. And I do have experience in IT, in new technologies. And new technologies is an area of law, an area of business that law is attached to, where English language, it's cemented its role as the modern Latin. Basically, that's the language that is spoken in business and in law related to new technologies. In addition, IT law is closely related to common law, because that's basically the legal culture where the IT advancement takes place, and every new concept, most of the new concepts are created. And now common law, where the IT comes from, where I practice, and civil law, where with jurisdiction I have around myself, they differ significantly. And they differ when it comes to the origin story of the law. It's really difficult to refer to some legal concepts which would date back to the ancient Roman law when reviewing the contract written in the business area of IT, which is basically related to common law. It's totally different conversation that I'm having with my counterparts, with my colleagues from the US or the UK, compared to the conversation I'm having with my Italian colleagues, German colleagues, or Czech colleagues. which have the legal order based on the same or very similar origin story dating back to ancient Roman law. Therefore, at this intersection of civil and common law, because of the very difference in the origin story, I believe that the lawyer must be very cautious when attempting to translate. And I would like to give you two examples where that cautiousness and open-mindedness towards the translation must be applied. And first is arbitration. For example, during the witness examination process, my experience shows that using an interpreter results in a huge loss of the dynamics and also of the content of the speech. When you're examining a witness for an interpreter, the party that must use the interpreter usually is in a worse position than the one that doesn't have to. The best is to ask the questions without an interpreter and in the native language of the witness. That gives you that huge advantage, especially during cross-examination. However, you also must be very careful to ensure that the witness understands questions well, especially if they claim that they can speak the language you're asking them to, but this is not their native language. And then also communication with the panel, with the tribunal. It's certainly easier than with the witnesses during the testimony, but it's important to verify, to check the legal background of your tribunal members. And my experience shows that sometimes it's necessary to provide a broader explanation of legal concept and its consequence in the legal system where the award will be enforced. When you're trying, for instance, to translate a part of evidence being a contract into language that the tribunal uses to issue an award. Taking, for example, Polish contract and trying to translate it to the tribunal members, or taking this Polish contract and asking questions from that contract to the witness. And that brings us to the contracts, which is the second very important area where the lawyer must be cautious, where simple translation is never enough. I simply believe that the contracts cannot be translated. Translation is even a misleading word that can be used that is used in the context of changing one language to the other of a contract, whether it's template or just translation for the purpose of litigation or informing your client what's the content of that contract. Contracts must be localized. It's simply impossible just to have a translation without thinking what words used in the contract are trying to convey which legal institution. To give some examples, contractual penalties, which are a direct translation of a Polish institution, probably will create a lot of confusion if translated verbatim into English language and used especially under the laws of England. In the same way, if an English person translates service credits directly verbatim into Polish language, also it will not serve the purpose and will make confusion instead of understanding. The same goes with American concept of LLC, limited liability company, which when translated directly into Polish so-called equivalent, also makes confusion about how this company operates and misleads what that company really is. Same applies to willful acts, to scope of licensing, to scope of transfer of copyrights, and to a bunch of technical terms in the IT world, which are a little bit easier when it comes to translation because of some consensus and lack of the heritage related to those words, unlike in law. However, still there is no single terminology framework for even the technical terms in the IT, making it difficult to just translate without thinking what's behind each word. And how to approach that matter of the intersection of civil and common law, which is intertwined with linguistical intersection of English and Polish. I just believe it's impossible to translate words. One must translate or interpret legal concepts that are behind the words. And obviously, it's often inconvenient to instruct a foreign law firm for each matter that appears on your desk, which contains English language. So solution to that challenge, I believe, is twofold. First is education in foreign jurisdictions, in the law of foreign jurisdictions like American law or English law, giving like broader scope and better understanding, allowing to explain those base concepts or understand what the other party is actually trying to translate to you. The other approach is having a good network of colleagues practicing in foreign jurisdictions with whom a lawyer, one of us, can discuss matters related to translation. Thank you.
Thank you very much for your experience and also for many practical pieces of advice. Then I would gladly pass the floor to Mr. Piotr Seder, linguist and sworn translator, who will show us his perspective of the legal translation matters.
Hi, hello everyone. Thank you for having me here. And I must say it was very interesting. It's always very interesting to hear the perspective of practicing lawyers on translation. It's not so common that lawyers and translators or linguists have time to talk to each other about translation and well, their differing perspectives and their trades. My background, my primary educational background is in archaeology, but I haven't practiced for over 10 years. I've been a translator for a decade or so. I started in 2011 or 2012, and I've been a licensed translator since 2016, and have been working as part of a team of translators. We mostly specialize in translating financial reports for companies that are listed on the Warsaw Stock Exchange. But we also do quite a lot of purely legal translation. We work with law firms on private equity transactions, on public offerings also. And most translation companies offer translation process management, but we are not project managers. We are actual translators. I must say that both Professor Fischer and Mr. Jarosiński covered most of the important aspects of translation already, and I'll touch on the same things, on the same translation issues. Let me start by quoting Roman Jakobson. He was a famous Russian American linguist who said that languages essentially differ in not what they can express, but in what they have to express. And this emphasizes the importance of concept in language. Concept is primary to words. So translation is essentially always about what we call reconceptualization. You have to express concepts in a different language. This is particularly evident in legal interpretation, but it's also very important in legal translation per se. Of course, as always, there are exceptions, especially within the European Union context. If you're translating something that concerns, that is somehow related to EU law, you're likely to, well, somebody has done translation for you already, and there is a translation in Polish, in English, or in a different language, and you're expected to use the same terminology. For example, listed companies often report in accordance with international financial reporting standards, and they've been officially translated, and they've been endorsed by the European Union. And as a translator, you have a little choice when you're translating a financial report. You have to stick to terminology that has been already set and approved and used. So while reconceptualization and translating legal concepts, not terms, is the core principle that should be followed, there are exceptions. Sometimes you have to translate terms. What else? Reading comprehension is an essential skill for a translator and doing research. This is often overlooked, and people often think that as a translator, you should master the foreign language that you want to translate into. That's of course very important, but reading comprehension and understanding your own language or the source text is as important, just as important, if not more important. And we also like to say that the translator does not only need to understand what's written down, a translator also needs to understand what's not written down. Because in every culture, in every system, you have rules that are expressed, that are written down, but there are also a lot of meta rules and meta principles that you can only learn by experience. They are not put down anywhere. They have to do more with culture than with law per se. But as Professor Fischer mentioned, there are different writing conventions, there are different writing styles, different writing cultures. And it can be a major challenge for a translator to render those cultural aspects also in a translator in a translation correctly, in order to make the translation sound as naturally as possible to a native speaker. To give you an example, the Polish legal writing culture, or in general, the Polish writing culture is vastly different from US writing culture. And take, for example, a simple legal text which is addressed to the guy in the street, to a consumer, like, for example, personal bank account terms and conditions. If you download terms and conditions for a bank account in the United States, it's usually a very short piece of writing, which is consumer reader oriented. It starts with something like congratulations on becoming an account holder at our bank, and it simply explains really the key concepts, the key terms and conditions, obligations, rights, and so on and so forth. And if you take a parallel text in Polish, it's you really, I mean, in the United States, most people, an average person in the street will be able to interpret such a text. And in Poland, nobody reads that stuff, by the way, but you really need a lawyer to decipher some of the provision in a bank account terms and conditions. So what else? And there are certain considerations or risks that you have to take into account also when translating not only legal concepts but also all the things that are around that, like cultural aspects of a text. There is a risk of over translating. There is a risk of under translating, and this is not unique, or this is not peculiar to legal translation, but this is something this is a challenge or an issue which is well illustrated by legal translation, because as Wojciech Jarosiński mentioned, you risk misleading your client or the tribunal. If you over-translate, you can over-interpret. If you under-translate, you omit something. So often you walk a very fine line, a very thin line. So, and Professor Fischer mentioned that a translation can differ depending on the audience, depending on the target audience, right? You can translate if you translate from Polish to English, you can translate for an audience in the United Kingdom, for an audience in the United States, in Australia, and you can deliver 3 different translations for those 3 different audiences. And we also have to remember that in today's world, you can translate into English for a non-native audience, or for a non-native speaker. And it's not only that, and you can translate for the general public. You can translate for a court of law. You can translate, so you name it. So for so many different audiences, and you can translate the same text in as many ways as you have audiences. And it's not like one translation will be better than the other. They'll just be different because they will serve different purposes. And I kind of agree, not fully, with Mr. Jarosiński, that sometimes translation is not possible. Sometimes you just cannot avoid sounding awkward, just a little bit awkward in the target language. And I think sometimes the best you can strive for is what I call Israeli English, because I think that Israelis speak really good English, but a native English speaker will know that they are not from the United States, they are not from England, although they might speak idiomatically and grammatically very good, very correct English, but still there will be a hint of awkwardness in their turn of phrase or their choice of words, and so on and so forth. But if you can achieve that, you will, I think, you will satisfy your client's needs mostly 90% of the time. But indeed, some texts call for localization or for rewriting, not for translation. For me, contracts is not really a good example, but I'm not a lawyer. I don't have so much experience with contract drafting. For me, texts that are intended for the general public, for consumers, I believe those should be rewritten. Those should be localized, and it's often difficult to translate them without leaving this, let's say, aftertaste of awkwardness. What else? One more thing I would like to refer to or mention is the thing that Professor Fisher mentioned at the end of her presentation, machine translation, which is I can't say it's an emerging trend in translation. It's already a well-established trend in translation, and there is no going back from that. Machine translation won't. It's a very advanced tool, and I must say, it's unprofessional not to use it, and it's already available. And there are so many machine translation engines. You just have to know which one to use for what purpose. They should be trained in a way that ensures high specialization, and in general, they don't make translation better. They don't make translations better, but they make the translation process much faster. They really accelerate the translation process and allow translators to, of course, take much larger volumes. And they enable us to deliver, let's say, rough draft translations really within a couple of hours, 3-4 hours maybe, after ensuring just some basic consistency and correcting small mistakes. You can get a translation that enables the reader to get the gist of the source text, which sometimes can be useful or sometimes is enough for the client. They don't need a translation which is impeccable. They just want to know the basic concepts. So yes, I guess that's it from me. If you have any questions, I'll be very happy to answer them. Thank you.
Thank you very much to you, and thank you very much to all the speakers for their very interesting stories and pieces of advice to all of us who probably translated or will translate at some point legal and not only legal text during our everyday life or professional. So I think we had one comment or remark, but it also could be a kind of question that I would like to share with you. One of the participants commented that translation is not just about verbatim rendering. It has never been, not only in law. This is just one of the possible techniques. So probably the question is about to you, whoever of you feel like answering or referring to this. What could be those translation techniques and how to differentiate using them? What extent maybe the addressee of the translation should know what translation techniques was adapted? So how would you refer to those differences between them, and particularly about the possibilities or dangers of using the verbatim rendering?
I guess that in law, the language is much more precise, especially in something like a contract, but even in a judicial opinion, or certainly in a statute. And so you have to be careful, more careful, I think, as I suggested in my remarks earlier, about moving far from the verbatim rendering because of the danger that you will twist the meaning and change the meaning of the word. And so law needs to be precise, especially where a particular term may not be exactly equivalent. The terms are hyponyms, that one is much broader than the other in the language. How do you convey that? And already you're moving away from the exact, there's no verbatim equivalent. But I would argue that you can't, it's probably better to remain more faithful to the concept. And I don't know if that's exactly verbatim or not, but you have to be aware of the precision of the language, rather than maybe how it sounds, how awkward it sounds, or how poetic it sounds in the, translated language.
Thank you very much,
Okay.
Professor Fischer. Would any other speaker, would you, Mr. Jarosiński or Mr. Musiela, like to comment or add on this?
Yeah, well, I can say that I agree with Emil with his remark. On the other hand, Professor Fischer is of course also right. It's there's no recipe for translation. It depends on so many things. Sometimes the verbatim approach will be the right one, but it depends on so many factors that you can say that one technique or one option or one approach is better than the other. It's just there are too many things that you have to factor in, including the target audience, the purpose of the translation. If you can be translating a statute for lawyers, right? Like the civil code. Foreign lawyers will look into that to understand something, certain Polish law institutions. But you can also translate the civil code, I guess, for students or for I can't come up with a better example right now, but sometimes in Polish the word to translate, tłumaczyć, can also mean same things. Sometimes you will have to abandon the verbatim approach and over translate just a little bit. I have a tendency to over translate, which has sometimes got me into some trouble, but let's leave that aside. But I feel that sometimes if you are sometimes you have to do a bit of explanation in your translation. Maybe a statute is not a good example, but you should elaborate on certain concepts or move a little bit away from just translating legal terms in order to enable the target reader to really grasp the meaning of the original text. And that's it.
I mean,
No recipe.
there is a lot of people have written theory of this, and I think there's been a movement in the theory. The original theory of legal translation was fidelity, that you had to be absolutely faithful to the original text. And so that would really, I guess, be verbatim, what Emil means by verbatim. But I think it's correct to say that some theorists have said, and even the UN in its guidelines for translators have said that you can move beyond that, but the movement seems to be dependent on what type of legal instrument we're talking about. So if it's a statute, fidelity is still incredibly vital in the minds of many theorists because it's a regulation, but then maybe there is room for freer form. You still have to bear in mind fidelity, as sort of the overarching principle, but that when you're dealing with something like a judicial opinion in American English or something, that maybe that is moving away from fidelity more towards allowing other methods of translation, so that it may, and sort of categorizing the legal instruments into instruments where you highlight fidelity as your overarching theory of translation or not. But there are definitely a number of theorists who have increasingly been writing about this specifically for legal texts.
Okay, thank you very much. I can see that the person asking this question commented it again. So I think that's a good moment to close the recording session and to remain discussing this, maybe with our participant actively asking his question and comment. So I start the recording.